Snotty little bastard.
Your Honor, I'd like to ask for a recess.
I'd like an answer to the question, Judge.
The court will wait for an answer.
If Lieutenant Kendrick gave an order that Santiago wasn't to be touched, then why did he have to be transferred? Lieutenant Kendrick ordered the code red, didn't he? Because that's what you told Lieutenant Kendrick to do.
Object!
And when it went bad, you cut these guys loose!
Your Honor!
You had markers inside a body transfer!
Your Honor!
You doctored the logbook!
Damn it, Captain!
Coerced the doctor!
Consider yourself in contempt.
Colonel Jessup, did you order the code red?
You don't have to answer that question.
I'll answer the question. You want answers? I think I'm entitled.
You want answers!
I want the truth!
You can't handle the truth!
Son, we live in a world that has walls, and those walls have to be guarded by men with guns. Who's gonna do it? You, Lieutenant Weinberg?
All right, welcome back, class. That introduction was suggested by your book in chapter 3. That's what we'll be covering today. And that is litigation. Hope you enjoyed that dramatic introduction to litigation. And what is litigation? Well, Black's Law Dictionary, which I've referred to before, defines litigation as the process of carrying on a lawsuit. The second definition is a lawsuit itself. So litigation, generally, we're going to go into basically what my job is, because I'm a litigator. And when I talk to attorneys and we talk to each other about what we do, a lot of times an attorney says, I'm a litigator. And to me, I look up that definition and I think, litigation, that's everything from the beginning to the end of a case. So aren't we all litigators? To me, that's a poor explanation of what an attorney does. If I think about it a little more, though, maybe my experience is a lot more about litigation. So I'm excited to share my experience with this chapter. And what we saw there was a clip from A Few Good Men. So this is a fictional, dramatic account of what happens in a courtroom, but I think it does give a good illustration of what a trial can be like and what it looks like in a courtroom and who the people involved are. So that's sort of what we're going to start with. We're going to talk about what people are involved in a case. Then we're going to go into important concepts, technical concepts that you need to know. One is standing and one is personal jurisdiction. And basically that involves the question, we're going to talk about who the parties are. Then we're going to go into what, where, when, and why. And that has to do with standing and personal jurisdiction. Then we're going to get a little more technical into pre-trial procedures. And then lastly, the trial and the appeal. And we'll end the case talking about what I think is probably my favorite case in United States history. My favorite case in the law, which is Brown versus the Board of Education, a U.S. Supreme Court decision from 1954. So I hope you enjoy chapter 3, litigation, with me. And starting off with sort of what you saw in A Few Good Men, now I'm going to share a video that's more like what we have going on today in the profession.
Waiters always look at me and think that I'm going to have a little salad, maybe a soup, and that'll be the whole meal. And when I do my actual order, this is priceless look on their face, like they can't believe, like, is someone else coming? I love food. I eat a ton of food.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to
can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that. I think if you click the up arrow next to this.
All right, so that's a funny example in the news recently of how the legal system and litigation is changing for us attorneys. And, because of the pandemic, we're doing a lot of stuff virtually suddenly. So a lot of lawyers haven't had a chance to catch up with technology. And this is a little funny example of what we run into here and there as we adjust to the evolution of litigation. All right, starting out with the parties involved. So in a civil case, we're going to have generally the plaintiff and the defendant. So the plaintiff is suing the defendant. We'll cover, torts, which is civil law in chapter 7. So you'll, I think, get a better idea of who a plaintiff and a defendant is when we get there, having to do with torts, when someone's injured and someone sues someone for that. And then, of course, in the second half of the course, when we get into contracts, you're going to have plaintiffs and defendants. Now, there's often more than two parties involved, and we'll especially cover that when we get into chapter 14, having to do with third-party rights. But a lot of times, cases will involve a plaintiff and a defendant, and then all of a sudden you bring in maybe an insurance company, or in a contract case, you've got maybe an assignee to a contract, or there's can be several defendants in a case, and maybe there's different people alleged to be involved in a case. In this chapter, we're going to look at a case Audi versus Robinson, which involves a car accident. And the person who actually is driving the car isn't sued in the case. We'll go into it more in detail, but the person who manufactured the car, the person who sold the car, those parties become defendants in that case. So a lot of times there'll be multiple defendants or multiple plaintiffs. In a criminal case, we don't have a plaintiff. We do have a defendant. We still call that person the defendant. But we have the people of the state of New York, or the people of the United States, depending who's prosecuting the criminal case. So we'll get into more of that in chapter 6 when we cover criminal law. But basically, we have the people, who is the prosecutor in the case, and the defendant, who's defending themselves. I like, when I do criminal defense, I like to call that person the accused, because defendant kind of makes me feel like I'm defending right away. Whereas if I point out that the person's accused and innocent until proven guilty, that puts me on a better footing, I think. In other cases, we'll be covering administrative law in chapter 5. And sometimes the person starting the lawsuit will be called the petitioner, and the person defending the lawsuit will be called the respondent. And then at the end of the chapter, we'll talk about an appeal. And the parties in that case will be called appellants versus the appellee. Okay. Now, a little Latin term, just to mix in some Latin like us lawyers like to do. I want to tell you what is called when someone's representing themselves. And that's called pro se. So 2 words, P-R-O-S-E, pro se. And Abraham Lincoln famously said, "He who represents himself has a fool for a client." Some of the lessons early in the chapter that I can't emphasize enough when you're going into business law is that as dramatic and fun that the clip you saw earlier with A Few Good Men, as fun and exciting as that can look to be part of, it's very expensive. And, sometimes people win a lot of money, but a lot of times, a lot of money is wasted in litigation. So avoid litigation. That's the lesson you can take from this. If I start to get into a lot of technical things, what I want you to think about is that that's why I have to charge a lot of money per hour, and other law firms do the same. And you don't know that you're going to recover those fees, those costs. So litigation can be very expensive, and you want to avoid it. Being a good business person is going to involve avoiding litigation. On the other hand, you need to know where things go if you can't resolve things between the parties, between their lawyers negotiating, or arbitration is something that's preferable generally to litigation. So, you have a sort of a third party, someone who's objectively looking at the case and using less resources, but looking at it through the scope of how it could go if it is litigated. And a lot of times that's a good way to resolve a business dispute. The next topic I want to talk about is attorney ethics. And, jokes aside, we have to observe our ethics, or else we can lose our licenses. Okay, so one of the main examples that you can think of is confidentiality. If you have me as your lawyer, you have confidentiality. I have to keep secrets for a living, and so does the rest of my office. And that's important because in business law, you might have secrets that you keep. You might have proprietary interests. Your business may depend on the information that you have, the trade secrets that you're using, those being secret to the general public. So when you have an attorney, you have confidentiality. Now, the exception to that is an ethical rule that happened relatively recently. It started to develop when I was in law school or in college, and it was a new rule at the time when I was in law school. And that rule is an exception to confidentiality in a way. And it's pretty technical, but think about it this way. If you tell me something confidentially as your attorney, there's an ethical rule that if we end up at a trial, which we'll be discussing at the end of the chapter more, I can't solicit perjury from you. In other words, if you're going to go up on the stand and you're going to tell something that's inconsistent with what you told me in confidence, and I believe that you'll be perjuring yourself, there's an ethical rule that I cannot solicit that, or I cannot make that happen as your attorney. And if I suspect that that's going to happen, I'm going to have to withdraw as your attorney. You can do what you want, but that's an ethical rule that I have to follow. So, you have to think about that at the beginning of a case, and I try to tell my clients about it. It's generally not an ethical problem because I like to believe my clients are going to be telling the truth, or we're going to rely on the truth if it goes to a trial. But just an ethical rule. Another example of an ethical rule is we're not allowed to engage in what's called ex parte communication. Again, that is a Latin phrase. And when you're dealing in litigation, the idea is that if you're going to communicate with the court, you have to communicate with the other party or parties. So if you write a letter saying, hey, judge, I want a hearing on this issue, you have to send the same communication to the other side. That's an example of attorney ethics that take place during litigation. Another one is attorneys are considered officers of the court. So when you saw that clip with Tom Cruise cross-examining the witness there, you had the judge was a little bit laid back there. I don't know if you would get away with that in real life. However, a judge at some point can interrupt an attorney and say, hey, you're out of order, and there's lots of things that can happen. If we're warned and we keep going, we could end up having a sanction, a suspension, something like that. We could even be taken to jail. I remember an attorney, when I was young in my career, attorney from Rochester, telling me about a case where he just had no confidence in the judge. And he started to suggest that it was a kangaroo court. And a kangaroo court is a term for a court that really doesn't administer justice. They are completely biased. And the judge warned him that he shouldn't be putting comments like that on the record. And then the attorney got excited and said, Your Honor, is this a court where the judge hops long distances? And kept ensuing that this was a kangaroo court. And eventually the judge got upset with him and had the bailiff handcuff him and put him in jail. So what judges are allowed to do at some point, if attorneys get carried away and they're warned, they can be held in contempt of court and they can actually be incarcerated. So I haven't had that experience myself, and but maybe that could happen when emotions get the best of us. But that's one of the rules. We're officers of the court. We're also not supposed to represent something to the court that we know isn't true, similar to that non-perjury rule that I said. So, in addition to not soliciting perjury from our clients, we have to be very careful if a judge asks us a direct question and says, you're an officer of the court, whether or not they can rely on you or not. And you can be disbarred if something like that happens. An example of disbarment that happened in my lifetime has to do with former President Bill Clinton. And you may or may not be familiar with his dealings with Monica Lewinsky. It ultimately led to sort of the end of his term as president. He was impeached, but there was a settlement. And, you know, I'm just going to show this video of him representing to the American people his involvement.
But I want to say one thing to the American people. I want you to listen to me. I'm going to say this again. I did not have sexual relations with that woman, Miss Lewinsky. I never told anybody to lie, not a single time, never. These allegations are false, and I need to go back to work for the American people. Thank you.
So, as you may know, the president wasn't convicted of any crimes or anything like that, but taking a look back at chapter 2 when it comes to
something that was once done only by men could be the key to taking years off your.
All right, still adjusting to this. Again, he wasn't convicted of crime. You know, he wasn't removed from office, but the bar of Arkansas, where he was governor, where he was a practicing lawyer, said, "Hey, you're an officer of the court. If you're going to mislead an investigation like that, there's going to be consequences." So Bill Clinton, as part of a settlement, agreed to a sanction of being suspended from the practice of law for 5 years. All right. Now, the next topic we're going to cover is when we get to a trial. Now, we're going to cover some important steps in between. But when we get to a trial, the fact finder is a very important concept of our legal system. So the fact finder is someone who determines the truth. And, you know, what is the truth? It's a multi-sided thing. You know, with body cameras these days in criminal court, we get, I think, a lot closer to the truth. But ultimately, the truth is what comes out of the jury's mouth or the judge's mouth at the end of a trial. And only about less than 2% of cases are going to go to a trial. And that's how the truth is going to be determined. And is it always true? I think history shows that it's only as reliable as human beings are. You know, we rely on a jury of your peers, or we rely on a judge or a panel of judges. So we're going to talk about that a bit more at the end of the chapter. But I do want to share this video. Well, first, in a civil case, you generally have the option between a judge and a jury. And a lot of the decision-making involves whether your case, if you're one of the parties and you're confident that a judge is going to make the right decision based on the facts, well, then you're going to want a judge. But ultimately, you do have a right to a jury. It's just, it's very costly. It can add a lot of costs because there's a jury selection process that I'll talk about toward the end of the chapter. And also there's more risk involved because, you know, you don't need, you got 6 people to make the decision in a civil case, not one person. So, and then when it comes to criminal law, you can choose a judge, but generally you want a jury if you're defending, because any one of those jurors can decide that they're going to hold out and not convict someone. And then the case we're going to talk about, Batson versus Kentucky, involves the jury selection process, which we'll get more into at the end of the chapter. But I think now's a good time to share this video with you.
Removing prospective jurors perceived as potentially biased, but without a showing of actual bias, has traditionally been done with peremptory challenges. Each party is given a certain number of peremptory challenges and can use them without having to provide any reasons. But can peremptory challenges be used to remove prospective jurors based on their race? The United States Supreme Court addressed this issue in Batson versus Kentucky. In 1982, James Batson, an African American, was charged in state court with burglary and receiving stolen goods. During jury selection, Batson's lawyer objected when the prosecutor used peremptory challenges to remove all 4 African Americans on the panel of prospective jurors. Consistent with the existing precedent of the United States Supreme Court, the trial court overruled the objection. An all-white jury convicted Batson. On appeal, the Kentucky Supreme Court affirmed his conviction. Batson successfully petitioned the United States Supreme Court to review his case.
All right, so when it comes to jury selection, that's a very important case, and it's relatively recent and definitely adds to our system of justice, in my opinion. We'll get more into jury selection and the process of a trial toward the end of the chapter. Now, the next concept we're going to discuss in 3.2, 2 important concepts: standing and personal jurisdiction. Again, what, where, when, why. The US Constitution, Article 3, basically gives our judicial system the power to decide cases and controversies, okay? So we have to have standing. The person has to have standing who's instigating a lawsuit. And there has to be what we call subject matter jurisdiction for the court. So we'll get more into this in chapter 4 when we talk about the Constitution, and we covered some in chapter 1, but there are certain subjects that only the federal system has jurisdiction over. In other words, the federal courts, not New York State, not Pennsylvania, the federal system, and the highest court being the US Supreme Court, and then the individual circuits. We'll look at a map toward the end of the chapter, but first of all, there are certain cases that are just federal. Then state constitutions sort of delegate powers to the individual courts. Now, I told you I'm only sworn into practice in New York State. I'm sworn into practice in federal court. However, other states are going to be different. But generally what you're going to see is under the Constitution, when we study chapter 4, certain kinds of cases, like if they involve parties in multiple states, obviously are going to be decided by a federal court. Federal courts can have jurisdiction over that. And then there are certain cases that are inherently domestic or are going to be only the subject matter of state courts. So think of divorce or something, matrimonial court. It's very rare that a case like that would end up in federal court because it's a domestic matter. So there's a whole spectrum and a range of, and there's overlapping, and we'll study that as much as business law 1 will allow, but just keep that in mind that we're talking about domestic cases when it has to do with state court, or if everyone is located near around the same place, or they all reside near the same place, the case is going to stay in that local court or that county court, or generally in the state. Now, the issues of a case must be ripe, okay? So they can't be premature. For example, in the book, it talks about if there's a law that's going to be passed and it's going to hurt a business, can that business preemptively sue the government and stop that law from happening because they believe it's unconstitutional? And the answer is no, because it's premature. The law hasn't had effect yet, so you don't have standing to sue. You're basically speculating, or you're asking the court to step in when it's not ready yet. Another thing is when something is moot or it doesn't have an effect on any of the parties anymore. Now that can happen sooner than you want to, and I want to talk to you about what's called the statute of limitations. The statute of limitations is a procedural law that says you have a time limit to file a lawsuit. And if you miss that time limit, you're SOL, statute of limitations, SOL. That's what that stands for. If you ever heard that before, that's what it means. Might mean something else, but in the legal world, that's what SOL means. The statute of limitations is expired. Now, generally, when we talk about a lawsuit, we're talking about 3 years. But when we talk about administrative law in Chapter 5, we're going to talk about much shorter statutes of limitation. So generally, statutes of limitation, when you're going to sue the government or an administrative agency, are very short. So as a business person, you want to know that. You want to be able to say, hey, the government is infringing on my business right now. You call an attorney right away, because I might only have 30, 60, 90 days to file a lawsuit. And that's not a lot of time in the legal world. If someone slips and falls in your place of business, generally they have 3 years. That's the general statute of limitations. When we get into contracts, we're going to talk about 6 years of statute of limitations. So the idea there is that contracts, take place over a period of time, and the courts don't want people just being very litigious and filing lawsuits right away. So they give us a much longer, double the period for that. And then with criminal cases and that, you see different statutes of limitation. And, for a case like a murder or something, there is no statute of limitations. So some crimes don't have one. All right, moving on to, let's see, that issue of standing. Now we're going to talk about a business case. This is Massachusetts versus the Environmental Protection Agency. So it's one of those cases I talked to before about administrative law. And basically in this case, you had Massachusetts and several other states that believed that the Environmental Protection Agency was not protecting the environment enough, because we started to know with science that carbon dioxide, the increasing levels of carbon dioxide may cause, detriments like global warming. So let's take a look at a little video about that case.
Originally passed by Congress in 1963, the Clean Air Act requires the Environmental Protection Agency, or EPA, to regulate the emission of pollutants that endanger public health and welfare. The Act also authorized state and local governments to enforce regulations, with oversight by the EPA. In 1999, a group of 19 private organizations petitioned the EPA, asking it to regulate the emission of carbon dioxide and other greenhouse gases from new motor vehicles. The EPA refused. The petitioners, along with several states that intervened in the lawsuit, including Massachusetts, brought suit against the EPA to determine whether the EPA had the statutory authority to regulate greenhouse gas emissions under the Clean Air Act. Massachusetts alleged that the EPA's failure to regulate these emissions would ultimately result in loss of its coastal lands due to increased global warming from the emissions. The EPA countered that any injury that may occur would be widespread and not a particular concrete injury to the petitioners, and that therefore the states, local governments, and private organizations lacked standing to bring the case in the first place. The Court of Appeals for the District of Columbia denied the petition for review, and the petitioners appealed. The U.S. Supreme Court granted certiorari. One issue on appeal was whether the petitioners could demonstrate a sufficiently particular and concrete injury in order to prove they had standing to bring this case. On the issue of standing, the court found in favor of the petitioners. Writing for the majority, Justice Stevens explained that when multiple challengers are involved in a case, only one of the petitioners needs to demonstrate sufficient standing in order for the court to review the case. Here, the court took special interest in Massachusetts' status as a sovereign state and based its analysis on whether the state was able to demonstrate standing. Stevens reasoned that because Massachusetts surrendered its ability to take action against other states when it joined the Union, the federal government has a special obligation to protect Massachusetts against harm from other states. Stevens explained that just as in a case brought by an individual plaintiff, an actual case or controversy must be present in order for the plaintiff state to have proper standing. An actual case or controversy is characterized by a truly adversarial relationship. A plaintiff can show the existence of a truly adversarial relationship by demonstrating that he has suffered a concrete and particularized injury that is either actual or imminent, that the injury is traceable to the defendant, and that it's likely that a favorable decision would redress that injury. Because Massachusetts was able to show that greenhouse gas emissions would further exacerbate the problem of global warming and ultimately cause the state to lose coastal lands, it had fulfilled this requirement. Additionally, the court found that the state was able to show sufficient causation between this injury and the EPA's failure to regulate greenhouse gas emissions because the lack of regulations contributed to the problem of environmental damage from greenhouse gases. Finally, although the impact would be small in light of the global problem of greenhouse gas emissions, the EPA's regulation of domestic emissions would in fact have an impact on decreasing the amount of emissions in the environment and thus reducing the amount of environmental damage to Massachusetts. Therefore, the court found that Massachusetts did have standing in this case. Chief Justice Roberts dissented, taking issue with the special status the majority conferred on Massachusetts. He explained that in any case, the petitioners bear the burden of demonstrating a particular and concrete injury that is clearly linked to the defendant's actions, and that a ruling in favor of the defendant would likely redress their injury. It doesn't matter whether the petitioner is a private citizen or a sovereign state. Chief Justice Roberts claimed that in this case, the petitioners had failed to introduce evidence that showed any petitioner, let alone the states, would suffer a particular injury distinct from harm suffered by anyone else. Roberts remained unconvinced that a ruling in their favor would do anything to redress their injury. This case is significant because it emphasizes that injury is a clear requirement of standing under Article 3. It also recognized that the states may have a lesser burden in establishing standing than private individuals. If you found this video helpful, you can explore all of our content by visiting us at quimby.com. If you have a question or comment about this case, please post.
All right, got to give them credit for putting that video together. But that's a case that went all the way to the Supreme Court, and we're going to sort of approach this from different angles. But I want you to see in that video how a case can work its way to the Supreme Court. And then we're going to cover another Supreme Court case at the end of the chapter, Brown versus the Board of Education. And I want you to just keep in mind that this is a very controversial ruling. There was a dissent by the Chief Justice in the case. So we might see this issue become more complex as the law evolves between administrative law, which we'll learn about in Chapter 5, but it's also going to creep up in Chapter 4 because it's not in the Constitution. So there's certainly an argument that it's not constitutional. All right. The next topic, let's see. So, you got to have standing. Another just, maybe a simpler example is if you think about, this was in a prior example of your textbook, but if you think about, let's say you own a home and you really enjoy your neighbor's garden. You think it's just the most beautiful thing that you've ever seen. And let's say a truck comes and drives over the garden and ruins it completely. And you just say, God, that's awful that happened to my neighbor. And it affects me because I really love that garden. And I'm going to sue the truck company. Or you talk to your neighbor and you say, you need to sue them. And they say, you know what, I'm not a litigation person. I've had that garden for a long time and I think it's time for me to take on a new hobby. And you say, you know what, I'm going to sue the truck driver that ran over that garden because I enjoyed it so much. Well, you don't have standing. That's the rule in the case. So generally, if you think about standing in a more simple context than the Environmental Protection Agency in the case that we just reviewed. That's a way to think about it. And it's an easy way for me to test on the issue of standing. Another example brought up in the book, and there's precedent for this, is you don't have standing as a taxpayer when you want to sue the government on how it spends its money, for example. So if you don't approve of a war that we're involved in, let's say we got troops in Afghanistan, and you say, I'm a taxpayer, I don't want my tax money going toward that. Well, there's precedent that you don't have standing to sue the government to stop a war, for example. So think about the balance between the precedents. You know, you can't stop a war. On the other hand, the Supreme Court has said that the Environmental Protection Agency has to regulate carbon dioxide to some extent. And of course, there's the evolution of law and all that could change. But I want you to think about the balance between those two precedents. All right, so we talked about subject matter jurisdiction. Now we're going to talk about personal jurisdiction over the parties. And this issue comes up a lot, especially in defense. If you're sued and you have a business and it's not located in the court's jurisdiction, you feel like, where you're being sued, then that's one defense. You're going to say, hey, you don't have jurisdiction over me as a person. And so the next case we're going to talk about is Robinson versus Audi. Audi's a automobile manufacturer. It involves a family that bought the Audi in one state. They're moving to another state, and in between they get hit by a drunk driver. And this is going to tell the story. This video is going to tell the story about how that happened.
Companies sell products that end up all over the country. But can the product sellers be forced to litigate wherever those products happen to go haywire? And does a special rule apply for products such as cars that are designed to move from place to place? Worldwide Volkswagen versus Woodson addressed those issues. Harry and Kay Robinson bought a new Audi in New York in 1976. The next year, they decided to move to Arizona, so they and their two kids drove west. Along the way, they passed through Oklahoma, and a reckless driver rear-ended their Audi. The car caught fire, injuring Mrs. Robinson and both children. The Robinsons filed a lawsuit in Oklahoma State Court, claiming that the car's gas tank and fuel system had been designed improperly. They named 4 corporate defendants, including the car's distributor and the dealer from which they bought their Audi. The dealer, called Seaway, operated only in New York, and the distributor, somewhat misleadingly called Worldwide Volkswagen, operated only on the East Coast. Both lacked any ties to Oklahoma and argued in a special appearance that the Oklahoma court lacked jurisdiction over them. The trial court disagreed and allowed the case to proceed. Worldwide and Seaway then challenged the decision at the Oklahoma Supreme Court.
All right, so again, there's a few concepts that are dealt with there having to do with jurisdiction, but basically when it comes to what court's involved, obviously if 2 businesses are located in Tompkins County or Cortland County, there's not going to be a fight about where the lawsuit's going to happen. On the other hand, you know, if you've got a car manufacturer in another country, and they've got business ties to a selected amount of states, and then they're sued in another state, they can say, hey, this isn't the place to resolve this case. Now that case involved the drunk driver, and the drunk driver didn't have insurance and didn't have any assets. So if I was the lawyer for the family, you know, I'm going to look for deep pockets because I want to get paid. I want my clients to get awarded damages, and I want those damages to be able to be collected. And you know, Audi or the manufacturer or the dealer of the vehicle is going to have money, whereas this drunk driver, he can't really correct what he did there. So, but there's other people responsible, and what you're going to learn in business law is that if you put something out there, you know, and the design is faulty, you may be liable for damages. So what we have here in this case And the case is known by different parties because there's a bunch of different parties involved. But the family's name is Robinson. The car is made by Audi. And basically, if they all were located in the same state, there'd be no fight over it. But they're all over the place. So what we talk about is long arm statutes, okay? So a state like Oklahoma can reach out and say, okay, Audi, or okay, Worldwide Auto, we're going to bring you in to our jurisdiction because you satisfy certain minimal contacts. And these minimal contacts can be, you know, if you're selling cars, you know, the video suggested that maybe a special rule applies because inherently you can take a car from one state to another and not even know you're crossing state lines. So that's sort of the evolving law that has to do with jurisdiction and how it happened in that case. Now, another concept having to do with personal jurisdiction is service of process. And, you know, we're going to cover due process when we cover the Sixth Amendment. But basically, whenever you're dealing with the court system, you have a constitutional right to due process. And one of the fundamental things involving due process is you have to get notice of a controversy, of a case against you. And you have to be served in a reasonable way. And so we're going to talk about, you know, how to start a lawsuit. So if I'm suing someone, I got to put together a summons and complaint. Basically, the summons is going to say why I think the particular court that I'm suing them in has jurisdiction over the subject matter and over the person. And then I have to find a way to serve that to the person because that's what a reasonable, this is a civil law. This is how we handle that. In criminal law, you get served with an accusatory instrument and you're given a date to come for an arraignment and you plead guilty or not guilty generally. But back to civil law and generally what we're going to be handling in business is you got to come up with a summons and complaint. And that's where a lawyer gets involved and states the controversy in a way that the court understands and another attorney who represents the other party should understand why the case belongs in the court that it's brought in. So you have to serve that summons and complaint. And generally, you try to do that in person. And there's other ways to do it if someone's avoiding service. But here's a couple of videos just about service of process where someone's being served papers. In the first one, we've got someone is videotaping a fake pizza delivery. So the person answers the door and they're served with the papers. And that's one way to do it. And of course, there's ethical issues you want to consider when you're serving papers, but this one, basically knocking on someone's door, hoping that they'll answer the door, and then if you know it's the person that you're trying to serve, then service is complete. The other example involves a celebrity, Tyga. He's a rapper, and I'm not sure what kind of case it involves, but basically he did a public appearance and the process server went to it and gave him the papers, and it was easy to prove that he was served with the proper notice. Now, the reason we don't let parties serve the other party or lawyers don't serve the other party is because if someone says they weren't served, that's a due process issue. That's a defense. And you don't want to have a conflict of interest with the person who says they served the papers. You want to hire someone or get someone else to do it who can testify under oath that they actually did it. And now with cameras and stuff, you'll see that it's a bit easier to prove that someone's been served with proper paperwork.
Pizza. Oh, we have a pizza here for you, ma'am. I don't know. It's got your name on it. Oh, wait. You have that served. Would you like some pizza to go along with that? It's very tasty. Are you sure? No. It's free. Why don't you take all that? Oh, no, it's okay. There. Would you like some pizza? No, you keep it. Are you sure? Get out of here. Okay. Nobody likes speak anymore.
Hey, what up, guys? Okay, today's a different kind of a video. As some of you know, I left the police department like 8 months ago, and I've been doing my own business serving court.
But what happened? What'd you give him?
I gave him my summons to appear in court.
Why? What's the charge?
It's not a charge. It's he's not paying somebody, so I don't know.
Not paying somebody? Okay.
Yeah.
So did you really have to buy those shoes?
No, I didn't have to, but I bought them anyway.
It's a good cover to give certain legal papers.
Yeah, I was standing in line for 2.5 hours.
Well, 2.5 hours to serve on legal papers.
Yep.
Wow, that's a big one. What's your name?
You call me Cal.
Oh, Cal. Thank you, Cal. I appreciate that, man. Take it easy. Enjoy your shoes.
All right, so that's what it's like in real life. You know, what you see in those videos is how you start a lawsuit, and it can be an uncomfortable thing, but that's the idea. You know, a judge wants to make sure that the Constitution is being obeyed and that due process is happening. And if you just send something in the mail to someone, or you send them an email, or you put an ad in the paper, those are things that the judge will resort to later on. But the preference is that you have this somewhat uncomfortable encounter with someone we call personal service. So that's how lawsuits generally are started. And we can certainly discuss that in live class more because it's interesting as a lawyer. All right, the next thing we're going to go into in 3.3 is pre-trial procedures. So we're almost to where we started out with the trial with a Few Good Men video, but we got to cover some pre-trial procedures. And this is procedural law, not substantive law. So we talked about this in chapter 1, but we've got procedural law, which has to do with timelines and how to do stuff. And this is what you really rely on lawyers to know about and how it's done. And then there's substantive law about, what the law covers, what the laws are substantively. But in New York State, we follow the CPLR, which stands for Civil Procedural Law and Rules. And in federal court, we use the Federal Rules of Civil Procedure. And basically that's the ground rules that attorneys have to obey, that we're used to, their timelines and things like that. So, the first thing that we do before a trial is called discovery. So discovery is basically trading the evidence between the parties because there's a trend toward avoiding litigation and not being surprised with evidence, okay? So judges, more and more, they are encouraging the parties to trade the evidence so they know what their chances are and not waste time with the trial. You shouldn't be holding stuff in your back pocket as an attorney for a trial. The judge doesn't want the case to go to trial, only if it needs to, because we have limited resources. So if the judge finds out someone's been withholding something in order to ambush the other side of trial, there might be a penalty for that. And the penalty could be that you don't get to use it at trial. So discovery is the process of showing your cards and making sure that both sides know what risks they're taking when they go to trial. And that's the that's the general idea there. So some of the things we do are we trade documentary evidence. So we serve demands on each other and we say, hey, what documents do we have? Another thing we might do is we might have a list of questions and say, hey, ask your client these questions because the answers might reveal, you might discover that your case isn't as strong as it was, or I might discover that. And then we also have depositions, which are similar to court, okay, but it happens in a law office. So I could have a deposition here at my office, and basically we could have the plaintiff and the defendant with their attorneys sit at that conference table. We could have a stenographer typing what everyone's saying, and then we may not go to trial because what's been said on the record, you know, what's been said in the deposition actually resolves the issues, and maybe a party doesn't have standing, or a party doesn't have jurisdiction, or maybe the facts aren't what we thought they were and it's time to settle. So that's the way our system works. 90+% of the time, we don't go to trial, and we resolve things by trading evidence. We have frank discussions. We make motions to the judge for preliminary relief, like a motion to dismiss because a case doesn't have jurisdiction, or a client doesn't have standing, or things like that. That's generally how cases go before trial. But, so that's motions, you know, and motions have timelines too. You know, we're trying to behave civilly, so lawyers make a motion, and if it's, you know, if there's a certain amount of time that the other lawyer gets to respond to it and they miss that deadline, well, then a judge can give a default judgment because the other party failed to respond. And usually it's seen that that's for a reason, you know, that maybe the case isn't as strong as the other attorney thought or their party thought. And then there's ways to reverse those. And I've got cases that have been going on for more than 10 years, and we're arguing over that kind of stuff. And sometimes it's because someone wasn't represented at the time, or, you know, the law changed somewhat, but that's what can happen. Now, going into 3.4, we've got the trial and the appeal. So I talked earlier about the fact finder when I talked about jury selection and a judge. And sometimes it's a few judges. It can be a panel of judges, or, you know, as students, you could be charged with a disciplinary matter. And I do a lot of student discipline. And the fact finder in a case like that can be somewhat like a jury, but it can be made up of, you know, students, faculty, and staff, like a mixture of people to be the fact finder. And in a trial for a civil matter, you know, generally we've got 6 people in New York State. And now I want to talk about the burden of proof. So in a civil case, the burden of proof is called preponderance of the evidence. And I want you to think about the scales of justice. Let's say I'm the scales of justice here. And preponderance of the evidence means more likely than not, more than 50%, just a little bit to one side or the other. And that's a civil case. That's the general standard. It's preponderance of the evidence, more than 50%. The next burden of proof you need to know, we'll discuss it more in chapter 6 when we cover criminal law. Because the stakes are so high in criminal law, people are going off to prison, their reputation shot. If you're convicted of something, it's because the prosecutor or the people prove something beyond a reasonable doubt. Now, beyond a reasonable doubt, I can't give you a percentage like I could with preponderance. Preponderance is more than 50%. But I can tell you that at the end of a trial, in a criminal court, the judge is always going to tell a jury that it's not enough. And I emphasize this in my opening statement when I'm doing jury selection. The judge is going to say at the end of a trial, when they're giving the instructions before the jury goes to deliberate, they're going to say, it's not enough that the defendant or the accused is probably guilty, because that's not the standard in criminal court. That's the standard in civil court. But the judge is going to say, if you merely find that the defendant is probably guilty, that's not enough. If you have reasonable doubt, you must acquit the defendant and vote not guilty. So probably is not enough in criminal court, and in civil, probably is enough for the party to win. So those are the basic ones you want to know. There's other standards of proof that as a business person you want to be aware of. I won't test on this, but there's what's called clear and convincing evidence. And that's more than preponderance of the evidence, but not quite beyond a reasonable doubt. That's the way lawyers have interpreted that, or judges have interpreted that. And then there's what's called substantial evidence. And substantial evidence may not be more than 50%. So that's the frustrating thing as a lawyer when you see that the burden of proof is substantial evidence. For example, in an administrative hearing, so a case involving the Environmental Protection Agency, for example, or the health department or something like that. If you've got a hearing in that case, the burden of proof is low. So you're at a disadvantage in a case like that. And then, you know, when that comes into play is if you're appealing or you're suing a governmental agency, you're at a disadvantage here. All right, so what it's like to be at trial. And, you know, if you have a bench trial, if you're dealing with a judge, then you skip the first step. But if you're dealing with a jury, and this is my favorite part of being a trial attorney, is picking a jury. So jury selection can be a lot of fun. You know, you're basically feeling people out. You're using a lot of intuition, and you're also using your objective skills. And, you know, you'll get the jury list ahead of time in a lot of cases, especially in criminal court. And you can do a lot of research and find out who you're dealing with. You know, you can look up people's Facebook pages, or you can look up their presence on the internet. You can look up public records, if they own a home, if they have children, things like that. You can find out a lot of that ahead of time. And the advantage to doing that is when you have people who have stuff that you can already find out, you don't have to waste a lot of time on questioning them because you have limited time to question them. Then we watched the video earlier about Batson. You have peremptory challenges. So you have a certain amount where you can strike a jury, you can have them removed from the jury based on maybe something you knew ahead of time or based on how they answered a question. Before you get there though, you do motions for cause. So you want to, when you're questioning the jury, we call it voir dire. And again, a Latin term, when you're questioning them, you try to get them, if you don't want them, you try to get them to answer a question where they show bias. And then the judge has to say that the person is removed for cause, or the judge can say, nope, that juror belongs on the jury as far as I can tell. You can use a peremptory challenge if you want. Anyways, it's a complex thing. I'm not going to test a whole lot on that, and we can talk about it in live class if you have any questions. So then after we have a jury, or after we know that a judge is going to be deciding a case, we have our opening statements. And with a judge, you usually waive that. The judge doesn't want to hear your opening statement, really. That's more for a jury. Then we do, usually the plaintiff or the people are going to go first, and they're going to put on their witnesses. And, you know, this is where due process allows someone the right to confront their accusers in a criminal case, or for due process, if they're going to take money from someone or take property, they have a right to confront the people accusing them. So you have the plaintiff putting on cases and trying to reach their burden of proof. And then you have the defense being able to cross-examine the witness and try to poke holes in their credibility, for example. And then after the plaintiff's case, so the people's case is done, the defense will always move for a directed verdict at that point, you know, especially just to preserve the issue, which I'll talk about a little bit later, what preservation is. You want to preserve it for appeal. And you want to ask the judge, leaving the jury out of it at this point, you want to say, hey, judge, the prosecutor or the people's or the plaintiff's case is so weak at this point, let's dismiss it, let's all go home. And if you can make an argument that they didn't meet their burden of proof at that point, case is over. The court doesn't, the court can issue a verdict at that point. If not, and in most cases, you know, it will have been obvious if the burden of proof was going to be met before a trial. But we'll move on to the defense case. So you have a right as a defendant, either in civil or in criminal court, you have a right to present evidence yourself. And then the prosecutor, just like you had a right to cross-examine the witnesses, the prosecutor has a right to cross-examine the witnesses for the defense. Then again, you make a motion for a directed verdict. And if the judge says, no, I'm going to leave this one up to the jury, then we go to closing arguments. And that's the most dramatic part of our judicial system, is when the lawyers get to wrap it all up and make arguments to the jury about why the case should go their way. After that, the judge will give jury instructions. So the judge reads from sort of prepared materials that the attorneys get to have a conference about and discuss. And the judge reads the instructions to the jury, and then they go and deliberate in private. And we wait for a decision. And then what comes out of the juror's mouth at that point is the truth. And that's how the case is resolved. The verdict. Except if they don't all agree, you have a mistrial, okay, in a criminal case. In a civil case, it's, depending on the state you're in, it can be a majority or a supermajority of the jurors. And then, of course, there's the option of appeal. And I mentioned preservation earlier. So as a lawyer, you're always thinking about appeal. If this trial doesn't go your way, you're objecting. Why are we objecting? We're saying objection, Your Honor. And if the judge doesn't rule in our favor when we make an objection, we're preserving that issue for appeal. So a higher court can decide that there was a problem with the trial and the case has to go back and there's a mistrial, it has to be retried. Or an appellate court can say, the whole thing's upset, there was a legal problem from the beginning and we're gonna dismiss the charges. Or there's a whole range of things that can happen on appeal. Now, most appeals you lose. So it's very few that actually get heard and actually get reversed. But appeals are decided on the law, not the facts. So when you object, you're objecting to the law. If a judge or a jury makes a determination that a witness is not credible or a certain evidence doesn't illustrate what you're trying to say, that is a factual issue that's determined by the fact finder, by the jury or the judge, and that cannot be overturned by an appellate court. On the other hand, if something goes wrong in a trial and it's a legal issue and the attorney objected, well, it's all there on the record and an appellate court can review that and they can send the case back. Now I want to show you the legal system that we're dealing with. So this is the structure of the courts. I'm going to share my screen here we're going to start with New York State. Okay, so we've got the structure of the court here. And in New York State, the highest court is the Court of Appeals. And in the middle here are appellate divisions. And in Cortland and Tompkins County, we're in the third department. So the third department is where I look when I do research for precedent. I'm looking to the third department. And I'm going to show you the map because it's hard to understand without looking at it. So here we are in Tompkins and Cortland County here. And this is the third judicial district here, this department, the third judicial department, the third appellate division. And our court is in Albany. Now this is the fourth department, which covers Buffalo, Rochester, Syracuse. Then we've got the second department, which covers the Hudson Valley and Long Island here, Staten Island, and then Manhattan, because it's so popular and there's so much going on, they get their own little department there in green. And when I do legal research, I always have this map next to me when I'm doing research so I can see what's binding on my court. So if I'm practicing in Cortland County, for example, I want to see what appeal decisions have been issued in Albany and what the precedent is. Then if a case goes past this point of the appellate divisions, it goes to the Court of Appeals, which is in Albany. So if a case goes to the Court of Appeals and it's decided, then that law covers the whole state. If it goes to Albany and there's the smaller court, the appellate division, that covers all the area in yellow, but it does not it's not binding on this area in blue or the area in orange or in Manhattan. So that's sort of what lawyers are looking at when we're doing research and applying precedent. And similarly, in federal court, we've got this map here. And we have circuits. So these numbers here are the circuits, and we're in the second circuit here. So there's federal courts in Rochester, Syracuse, for example. Here's the little, this is the Northern District here, and that's in Syracuse, and I've had to litigate in Syracuse. Or over here, we've got Rochester and Buffalo have district courts that I've litigated in. And if we appeal, we go to the second district, which actually covers multi-states. Okay, so most of these districts cover several states. And then if the case is, if there's a conflict of laws in these, between these circuits, then it goes to the US Supreme Court. So now we're going to watch a video about my favorite case, Brown versus the Board of Education.
It's early in the morning, and young Linda Brown, a third-grade elementary student in the town of Topeka, Kansas, is getting ready for school. Linda and her sister will soon leave the house to begin their journey, but they won't be going to the elementary school located just 7 blocks away from their house. No, instead, they will walk 6 blocks to board a bus that will then take them to another school located a mile away from their house. Why? Because of the color of their skin. The year is 1951, and this country needs a change.
It was a confusing time. Young African-American students were being denied the opportunity to attend school with their Caucasian neighbors and friends. They could play ball in the streets together and live in the same neighborhoods, but when they attended public schools, they were separated.
Sounds like backwards thinking to me.
Oh, hello, Stryker.
Hello, Professor McGee.
I was just telling the students about a time when people were questioning what equal protection of the laws as guaranteed by the 14th Amendment really meant.
Doesn't sound to me like it could be equal when kids were not allowed to attend a certain school because of their race.
Exactly the point. But for some reason, it took many years and a long journey for our legal system to figure that out.
Seems obvious to me.
Well, you're one smart little gavel. It was happening everywhere. African-American students were being denied admission to all-white schools, especially in the states where segregation was mandated. The case, Oliver Brown versus Board of Education of Topeka, Shawnee County, Kansas, was named after Reverend Oliver Brown from Topeka, Kansas. Oliver Brown was an assistant pastor, a welder in the shops of the Santa Fe Railroad, and father of 9-year-old Linda Brown. Brown was also one of 13 parents to be recruited by his childhood friend, Charles S. Scott, a civil rights lawyer. Brown and others were asked to attempt to enroll their children in their closest all-white neighborhood school. Reverend Brown did this in the fall of 1951, taking his daughter by the hand and walking with her into Sumner Elementary School. Linda was asked to sit in the waiting area with the secretary as her father spoke with a principal in his inner office. Voices were raised. Then her father returned to take young Linda by her hand and walk home. Linda was denied admission and was told to return to Monroe School, the all-black segregated school where she had previously attended.
That poor little girl. What a shame. All she wanted to do was attend school with her neighborhood playmates.
True. But now the NAACP had cases to argue, along with cases of 20 other students facilitated by these 13 parents. A class action suit was filed against the Board of Education of Topeka. The suit called for the school district to reverse its policy of racial segregation. The federal district court ruled in favor of the Board of Education, stating that separate but equal was fair. following the Supreme Court's decision in Plessy versus Ferguson from 1896. The district court panel did agree that segregation in public education does have a detrimental effect on African American children. However, they also concluded that the Topeka schools were pretty equal when it came to buildings, teachers, and curriculum, and so, ultimately, relief was denied. But don't worry, we're not done yet. In fact, we're just getting started.
All right.
It took 3 long years, but eventually 5 similar cases from Kansas, South Carolina, Virginia, and Delaware were consolidated into one case, and Brown versus Board of Education of Topeka was headed to the Supreme Court.
Why did the Supreme Court agree to hear the case? Did the plaintiffs have a new angle?
Good question. By 1954, these cases were creating a lot of hype because of their civil rights implications. This was a hot topic in America at the time. Verdicts from other civil rights cases, such as Plessy versus Ferguson, which had defined race relations for 60 years, were coming into question. Would the Supreme Court uphold the current interpretation of equal protection under which racial segregation was allowed, or would they deem it unconstitutional and change it? Well, let's find out. Thurgood Marshall, the chief counsel for the NAACP, argued the case for the plaintiffs, stating that segregated schools were not and could not be made equal. The Board of Education lawyers argued, citing the definition of equal protection from Plessy versus Ferguson, that as long as facilities for separate races were equal, they were equal according to the 14th Amendment. But in the end, Chief Justice Warren declared that even if physical factors of segregated schools are equal, separating children from others based on race causes feelings of inferiority, which may be permanent. The court rationalized that intangible factors made segregation laws for public education inherently unequal.
And so,
on May 17, 1954, the Supreme Court ruled in favor of the plaintiffs in a unanimous 9-0 decision, which meant that all school districts across the country had to reverse their policies of racial segregation.
Cool. So Linda and all the kids got to go to school with their friends?
Yes, and well, no. Since the Supreme Court's decision did not spell out any sort of method for ending racial segregation in schools, it took time to implement these new court mandates. The states were given the task of figuring out how to best desegregate their schools. Some did better than others, and it took a while. But it was a start. In fact, this case ultimately led to the desegregation of hotels, lunch counters, and many other public places which had previously been segregated. It was a time of change for African American students, which led to much change in America, a country which desperately needed to update some of its policies, ensuring the freedoms and civil rights of each of its citizens. The case also opened doors to better foreign relations for the U.S., which was being ridiculed at the time by other countries for its discriminatory practices. And the Plessy versus Ferguson decision was overturned.
Boy, Mr. Marshall did a good job arguing that case for the NAACP.
And you know, he went on to become the first African-American justice to serve on the Supreme Court.
No fooling.
Yeah, no fooling.
Well, all's well that ends well.
Do you mean begins well?
Right. It ended up well, so now it's like there's a new beginning, which could end very well, and did okay.
So, what case would you like to learn about next?
All right. So there's a lot to unpack there.
The local newspaper, the Arkansas Gazette at that time.
But, you know, some of the things that you see are how a case works its way up to the United States Supreme Court, how someone has standing. Okay, so you remember the father had to take his child and actually get rejected from the school in order to have standing to sue. Other people did that around the country, and which are similar things around the country. And what you saw is when they showed the map of the United States, it was similar to the map that I showed you. And there was disagreements between the different circuits. So that's why a United States Supreme Court steps in and decides an issue like this. And this case isn't just civil rights. It's very much related to business law, because as they pointed out at the end there, the case involves schools initially, because that's probably the most sympathetic angle to approach it. And you've got children who are being segregated and how that makes them feel. And is that American? No. 9-0. That was a unanimous decision. It's very rare that the United States Supreme Court decides unanimously. We also saw it in Harris v. Forklift in chapter 1. But that's rare. Usually there's a divide between conservatives and liberal justices. But the time was ready, the time was ripe for segregation to be eliminated from the United States. And that's what that case decided. And it overturned the precedent from the end of the 19th century. I think it was 1896, Plessy versus Ferguson. So 60 years before that, there had been a law carving out a way for segregation to exist. And then by 1954, it was completely tossed out, completely reversed, and 9 out of 9 justices agreed to that. So it's a very rich case to study historically, and it's a segue into chapter 4, and we'll go into the Constitution and constitutional law in chapter 4. All right, that's the end.